In LODHIA versus 12 Trees Management Company, BROMLEY-BY-BOW Limited and others, Mr. Justice Linden determined the costs consequences arising from the claimant's discontinuance of defamation proceedings against 5 defendants connected to a residential estate management dispute in East London. The claimant, a litigant in person who described himself as a legal consultant, had issued proceedings in May 2025 in respect of a newsletter that accused him of dishonesty and misrepresentation. Rather than filing a defence, the first and third to fifth defendants applied for summary disposal in July 2025. The claimant vigorously resisted that application until January 2026, when he applied to amend his particulars of claim, abandoning his malicious falsehood claims, deleting the fourth and fifth defendants entirely, and reducing the statements complained of from 11 to 6, thereby conceding the application in full. He subsequently filed a notice of discontinuance on the 30th of April 2026. Applying Rule 38.6 and the principles in Brooks v HSBC Bank, the court held that the presumption that a discontinuing claimant bears the defendant's costs was not displaced. The court found no relevant change of circumstances attributable to unreasonable conduct by the defendants, rejecting arguments based on pre-action protocol breaches, alleged shifts in the defendant's position on meaning, and remarks made by a defendant at a residence meeting. The claimant was ordered to pay the defendant's costs on the standard basis, with an interim payment on account of £55,000 plus VAT to the first and third to fifth defendants, and £3,600 plus VAT to the second defendant. Quote, Mr. LODHIA argued that the usual consequences of discontinuing proceedings, as set out in Rule 38.6, should not follow in this case. He put forward a number of reasons why the presumption identified in this rule was rebutted, and all the defendant's costs should be disallowed. I have considered them all, but they do not, individually or cumulatively, amount to a relevant change of circumstances, and/or one which has been brought about by some form of unreasonable conduct on the part of the defendants, which in all the circumstances provides a good reason for departing from the rule. Nor do they amount to unreasonable conduct on the part of the defendants, or any of them, which would cause me, in the exercise of my discretion, to disallow their costs in whole or in part.
For a detailed summary of this decision, visit tmclegal.co.uk.